Reading forthwith. Honourable Chris Tremaine.
Mr Speaker, I move that the Reserve Bank of New Zealand Covered Bonds Amendment Bill be now read a third time. The bill sets out a legislative framework for the issuance of covered bonds by New Zealand registered banks. It will provide greater clarity both for investors in covered bonds and for depositors as to the treatment of the assets securing the covered bond in the unlikely event that the issuing bank defaults. The bill establishes a registration regime for covered bond programs. An issuer commits an offence if it issues covered bonds other than under a covered bond program registered by the Reserve Bank. In order to be registered, the program must meet certain registration requirements. These requirements aim to ensure that the cover pool assets are effectively segregated from the bank's other assets, and a cover pool monitor be appointed to the covered bond program to provide enhanced monitoring. Following registration, Mr Speaker, there are ongoing requirements on issuers of covered bonds, in particular reporting requirements. The issuer is required to keep the register of cover pool assets up to date, and the cover pool monitor must be required by their contract to assess the issuer's compliance with that requirement. The bill then clarifies the application of the law in relation to cover pool assets of a registered covered bond program in the event the bank that issued the covered bonds is placed into statutory management or into liquidation. The bill includes a transition period that delays the application of the bill to existing covered bond programs to allow time for amendments to be made to the programs to meet the registration requirements. This bill is important as it will improve the access of New Zealand banks to offshore covered bond markets. Covered bonds enable banks to obtain finance at reasonable costs at times when it is difficult to issue other forms of debt. Further, covered bonds provide New Zealand banks with a source of long-term funding, which is important to reduce the vulnerability of the New Zealand economy to sudden changes in investment sentiment. This helps to promote overall financial stability, and as such it does benefit all New Zealanders. Finally, Mr Speaker, I would like to thank the members of the Finance and Expenditure Committee for their prompt consideration of this bill, and also to officials who have engaged with the industry and with other political parties. Mr Speaker, I commend this bill to the House.
The question is that the motion be agreed to. The Honourable Clayton Cosgrove.
Mr Speaker, as we've already said, and we won't labour the points, the Labor Party will be supporting this bill with some reservations. We note that covered bonds already exist and can be legally issued in New Zealand, but lack a regulatory framework which in itself could indeed generate stability. So opposing the legislation won't prevent the issuance of covered bonds. It'll merely leave, as I say, New Zealand without regulation. We note that the effect of covered bonds is to create a class of lenders to banks who have a higher level of security over banks compared to others. We've said in the previous speeches that have been made that we have some reservation about this, given that there is an inherent unfairness that a two-tiered system is created. Most covered bond holders are foreign institutions. The question is where that leaves mum and dad, and we know in recent days, as we noted in the committee stage, that preference to foreign entities, institutions, brokerage houses and others has been evidenced over and above mum and dad shareholders, contrary to government policy, stated policy and commitment, has been evidenced through the recent sale of Air New Zealand, where the government went out to the big end of town, and the best mum and dad could do was wait until the share price, wait until the shares hit the market and then make a purchase. That was not the agreement. We know the big end of town and the foreign institutions were in, like big hungry dogs, hoovering up those shares, as was the case with Meridian and Mighty River Power. So as we said in the committee stage, there is a series of precedents where this government has preferred the large corporates in the formation of government policy in respect of the film industry, Sky City, Rio Tinto,